A reminder from WESN.
Good day and welcome to another episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Donawa, attorney at law, and of course you can stream us on www.wesncc.com and on all social media platforms. I am happy once again to bring the law and you. So today we have a very interesting topic dealing with employers' liability and the employer's duty to the employee, particularly when it comes to negligence, as well as what is their duty. And of course, in the advent of COVID-19, there are a lot of questions surrounding employer-employee relations. How can employers provide a safe working environment along with other different areas of law? Now, I don't want to get too much into the legal aspect because we have a guest with me today connecting us via the web. His name is Mr. Prakash Maharaj, attorney at law. Mr. Maharaj, I will just give you a little bit of overview of who Mr. Prakash Maharaj is. He pursued his legal practice course in England and was admitted to the Bar of Trinidad and Tobago in 2010. He has over 11 years experience in private practice at Gordon Street, San Fernando. Prakash's main area of expertise includes civil practice, which also includes negligence, personal injury, insurance law, land contract. Now in 2010, Prakash was recognized by his alma mater, CJOS Secondary School, as being the first attorney at law coming out from the school. So he's a proud CJOS South boy. Right? He's an avid cricketer and plays the Trinidad and Tobago Lawyers cricket team under the leadership of the Honorable Mr. Justice Tam. He also played on the West Indies Lawyers cricket team in the past, which was the Lawyers World Cup in Sri Lanka and India. Prakash and I worked together in practice for the last 6 years, and we have done a lot of matters together, including the notable arbitration case with respect to Miss World Organization and the Trinidad and Tobago representative. So without further ado, I bring to you Mr. Prakash Maharaj, attorney at law. Good morning, Prakash.
Good morning, Rondell, and thank you for having me.
Great. So as we were discussing, thank you for joining me. And I know this will be a very interesting topic. Now, on the issue of employers' liability, tell us what is employers' liability and some of the duties which are owed to the employee.
Right. So employers' liability, in layman terms, is simply the employer's duty to compensate its employees for any injury, illness, or harm suffered or sustained by an employee during the course of his or her employment. And this must be as a result or occasioned by any negligence or what we call blame on behalf of the employee. To answer the second half of your question, what are the duties? There's what we call a general duty of care, a common law duty of care. So as you will know, common law is cases or precedents which has been decided by the courts over the years. So a definition, a legal or even a layman's definition of the general common law duty of care is simply, again, putting it as a duty of care by the employer to take all reasonable safety precautions to ensure the well-being of its employees and also not to expose the employee to unnecessary risk. And this common law duty can be classed into different categories or headings, so to speak.
And what are those headings in terms of that common law duty?
Right. So the four main headings I would say would be firstly ensuring a competent staff. So this would mean hiring persons who are certified to do the job at hand, adequate training and disciplining employees. So to provide some practical examples would be you should not or not to hire, or breaches can occur where, for instance, you hire an electrician to perform an electrical engineer's job. So the employer can be seen as breaching that duty. Or more simple and more common examples, I mean, you hire your neighbor's son to help you out in your business because you're trying to help out the neighbor, and he wasn't competent to provide the task at hand, causing injury to himself. So those are some of the practical examples of hiring a competent staff.
Yes.
It will also cover putting a stop to any what you call practical jokers in the workplace who can cause injury to co-workers.
Yes.
Secondly, the employer, I would class this as has a duty to provide adequate equipment. So this would cover machinery, ensuring that the machinery is in good working order, providing PPE, safety devices, and let's say you're working in somewhere like a kitchen environment, you're under a duty to provide a simple device like a fire extinguisher. So a breach can occur in a simple corner kitchen, let's say cross-crossing example, and though you're making burgers and a fire occurs, cause injury to an employee, just failure to have a fire extinguisher in place to put out a fire, the employer can be seen to have breached this duty. Thirdly, we have a safe system of work. This is adequate supervision, clear instructions, if there are areas out of bound, to make sure these areas are cordoned off. And employers, unfortunately, has additional burden to ensure workers follow such a system. So, for example, you are an employer, you have to not only provide PPE, but you have to ensure that the workers wear PPE, because you have to take into account that workers are sometimes careless.
Yes.
And finally, we have a safe workplace. So this is a little more tricky because it is offices and job sites, but we have to understand that some job sites, employers don't have full control over. So they are under duty not to expose the employee to unnecessary risk, but they can't discharge this by taking reasonable steps to make sure the job site is safe, although they may not have control of the job site. And once the employer does these acts, they can discharge their duty to the employee, regardless if an incident or accident happens.
Now, we're dealing with, of course, the common law duty as well. Now, let's say, for instance, an employee would have caused another employee's harm due to that employee negligence. Is the employer liable for that employee's negligence in the workplace?
Yes. The simple and general answer is yes, because as lawyers, we know there is a legal principle of vicarious liability. That's where someone can be held accountable or responsible for someone else's action. So the employee who caused the harm, once in the course of his employment, would be deemed the servant and or agent of the employer. So you are carrying on the employer's business. So you cause harm to yourself or someone other than yourself, a co-employee or a third party, the employer would be liable. And this is the general rule. There are exceptions, but this is the general rule in law.
Right, and of course, each situation is based on its own facts.
Yes, each case can turn out its own facts. Correct.
And we have discussed the common law duty. Now, are there any statutory duties as well with respect to employee safety?
Yes, there are statutory duties. A common example in our jurisdiction would be the OSH Act, the Occupational Health and Safety Act. Sometimes referred to as the OSHA Act, but that's erroneous. OSHA is the body, and the OSH Act is the statute. There are also implied contract terms, but this is basically the same as the common law principle.
And of course, what are some of the duties with respect to the employer under the OSH Act?
Right. So the duties are, the OSH Act defines general duties, but my interpretation, the general duties is the same as the common law principle. However, the Act also provides specific requirements and criteria for certain sectors. So, for example, the industrial or manufacturing sector may have additional criteria for an employer than an office environment. So some of the examples that would be in the OSH Act would be simple things like additional requirements to have your building certified by OSH or OSHA. This would mean having fire service inspect and approve the building, first aid kits, proper sanitization, lighting, ventilation, to prevent overcrowding, preparation of annual risk assessments. And due to the pandemic, there may be additional responsibilities in employers on high-risk jobs. For instance, someone working in a lab and is testing for the COVID-19 virus. The employer has to do surveillance and certain additional checks and certain testing. So there are a lot more obligations under the Act or under statute.
And are there any potential liabilities to the employer pursuant to the Act if they fail to provide such safe environment, or if a worker falls ill subsequently?
Well, pursuant to the OSH Act, yes, but that's for the body OSHA to pursue. So when an incident happens, sometimes regardless or not if the employee suffers harm, OSHA does an investigation and will prepare a report. And if the findings of that report infers breaches of the OSHA Act on behalf of the employer, OSHA can commence proceedings or prosecute the employer via the industrial court. And each breach is seen as a separate fine and a separate charge. And OSHA can also impose sanctions on the business, for example, closure, issue notices, and the notices can be improvement notices, how to make the business function better, system of work better, and is really geared towards preventing further incidents.
So we are saying that there are penal sanctions in terms of fines or let's say jail term, as well as a civil proceedings can be brought.
Yes, but each person has different causes of action. So the OSHA would be involved in terms of filing charges against the employer by an industrial court, and the individual who has suffered harm, in this case the employee, has his legal recourse under the common law principle.
Now, let's say an employee suffered harm. They are now seeking some sort of legal action. How does that employee go about seeking that legal action against the employer?
Right. Well, there are mainly two causes of action. You can pursue the claim under the common law, what we call negligence. That's to get compensation for one injury. So for instance, you have a broken hand, you commence this negligence or common law action. To rely on breaches by the employer, you can get compensation for injury, loss of earnings, loss of expectation of life if you die, medical expenses, cost of surgery. So that's the negligence or the compensation action. There's also a workman compensation action the employee can.
Right. Now, before we get to the workman compensation action, now there are various scenarios where employees we understand that employees means persons who are in the workplace regardless of whether they are permanent or contractual. Now, let's deal with laborers. For instance, contractors, subcontractors. Now, a scenario is that, let's say the Ministry of Health is building a hospital and they would have contracted a main contractor, and the subcontractor would have been contracted by the main contractor to, let's say, to put up steel beams or the foundation. And a worker or employee of the subcontractor got injured on the job, breaking a foot. Because of the fact that a steel beam fell on him. Now, what is the chain of liability with respect to who is the one has to pay for that injury?
Right, so that also touches beyond employer's liability, as element of law of occupiers liability may come into effect. So to try to answer that scenario, there are four parties. So the Ministry of Health, by the process of elimination, by hiring this contractor to do the work, would have already absolved or discharged its duty. So the Ministry of Health would not be liable. The contractor now hires or subcontracts a specific company to do the steel work, structure, the concrete, and so on. It can be seen that this contractor has also discharged its duty. So to answer the scenario, generally, the subcontractor, who coincidentally is also the employer, would be liable. The caveat in this scenario, however, is that if the main contractor retains some sort of control over the site or is able to dictate the manner in how the work is performed by the subcontractor, the main contractor can be liable or also jointly liable with the subcontractor. So again, each case will turn on its own particular fact.
Right, and therefore, is it that now, let's say the employee, or rather the worker or the employee, yes, they are unable to work within that period? What sort of redress can that employee get with respect to compensation?
Well, right. So this is more leaning towards the workman compensation action. So workman compensation is the benefits due to an employee who has suffered injury in the course of his or her employment. It's governed under the Workmen Compensation Act in our jurisdiction. We have a Workmen Compensation Act. And the act is not really geared towards blame or fault of the employer. It geared towards you get injured while working, you're entitled to compensation. And there's also the negligence claim as a separate act. That one is blame. And that tends to be the larger claim because here you want compensation for your actual pain and suffering and all your consequences.
Well, and there are some misconception among employers that because they are paying workmen compensation, it means that is damages for an injury. Is that in fact correct?
Right. So that is not correct. But I agree with you. A lot of employers are of the view, well, I paid workmen compensation and I've done I will discharge my liability. That is not true. Workmen compensation, I said, is treated separately. You get injured, you're entitled. There's an entitlement. The negligence claim is blaming somebody who has caused harm to you. And that's a separate claim. And that's the claim where you will get compensation for your pain and suffering. However, you are entitled to pursue both matters, but there are principles in law where one cannot get double compensation. So if you are paid workmen compensation and then you pursue a negligence claim and is successful, in awarding the loss of earnings, the court will deduct the workmen compensation for what's already.
And who is qualified? Is anyone who does a job is qualified for workmen compensation?
General answer is yes. The Act provides that any workman is qualified for workmen compensation as defined in the Act. So a layperson's definition of a workman under the Act would be any person who is engaged in a contract of service for some sort of income in the end of the day would be an employee or a workman. However, there are exceptions, and I can draw a practical example. You live in Trinidad and Tobago. Let's say you have a family business downstairs. You live upstairs with your parents, you have a family business downstairs, you're downstairs helping out in the business, and you get injured. The Act would not deem you a worker or someone entitled to make a claim. The Act also sets out a threshold to meet. For instance, to be eligible for a claim, you must be incapacitated or disabled or unable to work for a minimum period of time. And even if you meet the requirements under the Act, there are exceptions also where a court can disallow a claim. For instance, willful misconduct. The employee did something so bad or wrong, willfully cause injury to himself. A claim can be disallowed. But again, each case will turn on its own fact.
And okay, as we're on the topic of workmen compensation, I know this is an exhaustive issue because a lot of legal principles overlap, of course. Now, there are a lot of issues now where, I would say that I got 2 questions from persons who are now permanently employed, however, because of the COVID-19, because of restrictions, because of work of home principle now, there's a scenario whereby one individual is working in an institution that requires them to sit on a chair and watch the screen all day, interacting with customers, etc. Now, they were now told that they have to work from home. Of course, certain individuals don't have that luxury of having office chairs, having proper tools to work at home. Now, are the employers responsible for the employee's safety while they are working at home in terms of proper equipment to work? Because at the end of the day, they are working within their employment remit.
Right. So this is what we call a novel scenario because the pandemic is only recent. So cases have not yet been tested in our jurisdiction to see how the court will apply the law. We know what the law is. Employer is responsible for providing safe system of work, safe work environment, a home office. So you're working in an office. So you, as employee, you might say, well, my employer has to provide the desk, the chair, the computer for me. But due to the circumstances, I can see the court saying, well, the employer did what he could in the circumstances, right? Because each case turns on its own fact. and it wasn't reasonable for the employer to provide these things, or the employer doesn't have control of your home. Let's say a company sends home 100 workers to work at home. Is this company now responsible to inspecting or providing 100 home offices? So it's really difficult to answer because of the newness of the scenarios. So I can see a negligence claim being heavily contested. In terms of workman compensation, well, as stated, that's not necessarily geared towards blame. So if someone can prove, well, I suffered some kind of injury while performing my duties, I can see that being awarded much easier as compared to a negligence claim, which is geared around blame of the employer.
But again, can we say now that there's an implied term within the contract that, I mean, the employer has to provide safety to the employee during this period? Like, for instance, these employers have office chairs in they're just sitting down, and an employee requests that office chair to work at home. Is it unreasonable for an employer to provide that employee with an existing office chair that is just there?
Right. So each circumstances will be treated differently, but in those circumstances, I can say yes, the employer is under duty. Chair is there doing nothing, working from home. There is no harm in carrying the chair home because the employer is under this general duty, this general common law duty. And this duty also is something that the employer cannot delegate. So the employer cannot delegate to his employee, well, you need to sort out yourself. This is something that the employer cannot do, right? But the employer must do what is reasonable in the circumstances. But that's the test, right? Take all reasonable precautions.
Now, let's shift away from the workmen compensation, get back to the duties of the employer. Of course, we've seen a lot of instances where the Ministry of Health would have produced public guidelines to employers in terms of providing a safe working environment due to COVID-19. There are a lot of employees who have contracted COVID-19 at the employers, at their place of employment. And they are asking the question, do I have a claim of negligence from my employer for not providing a safe work environment, despite me as an employee trying to keep safe, or me as an employee telling the employer that they are supposed to provide that safe environment?
Right. So contracting COVID-19 in the workplace as a result of my employer's breach, whether common law or breach of statute like the Ministry of Health providing safety regulation. It's again a novel scenario, so we have to wait until cases are filed and tried and determined for us to properly comment. In such circumstances, as you would know, there's not only employers' liability to consider. So an employer might very well breach his duty under the Ministry of Health guidelines or common law, cause its employees to contract COVID. But public policy, right? I think that's a hurdle that will come into play with a court, with a public policy award damages for such a scenario, because COVID-19 is a disease, so there may be certain other acts or elements of a claim to be considered. So without cases, it's difficult to say how the court will apply. So yes, in theory, there will be a viable claim, but succeeding now is another issue, because the employer will be entitled to raise expenses. For instance, I mean, you know that we cannot even take action against China for the spread and the initial cause of the disease, whatever it was.
Yeah. So it is okay, based on your opinion, do you think that this will open the floodgates, as you said, to multiple class actions, basically where one person suing the employer suing another employee, and so it's going?
Yes. So again, this is my opinion. So I can be wrong, but that will open. That will open floodgates. That's the public policy position I am saying, because you would not only have now employees suing employer, you would have employers now filing actions against a customer who knew they were COVID positive coming into the business space. You have neighbors suing neighbors, and then there's the issue of asymptomatic people not knowing they are contaminated or contracting disease. So it will open floodgates. Basically, if a court allows that, I can safely say that other persons can sue their neighbor, their friend, their family member, the girlfriend, and so on, for spreading the disease. So I know employees are aggrieved that the employers are probably not doing what they're supposed to do under the Ministry of Health guidelines. But being something new and novel and taking into account public policy, I can personally see that as a difficult claim to succeed contracting COVID-19.
Right. And now, one get injured on the job in the workplace, of course, they want to seek redress. Can you just walk us through the steps in terms of how can that person seek redress for personal injury as a result of that negligence?
Right. So the personal injury claim would be the employer's liability claim. The standard procedure where we send what you call a pre-action protocol letter. If there's no resolution of the matter, then you file a claim in the High Court, and the court will determine your loss based on the evidence of both the breaches and injury aspect. This is also a iffy scenario because sometimes the employer of the employer. So what it means is that you are suing your boss, and you may require your co-workers to assist you to give evidence. The co-workers might be giving evidence against you. So this is where good industrial practice will have to dictate, which is, a separate issue if the employee is not victimized.
And can the employer now set off that liability by stating that, okay, the insurance can now pay that employee for that injury?
Well, not set off, yes, but it's more upon once the employer is liable and they have this negligence or workmen compensation insurance, they basically call upon the insurance company to pay or indemnify the claim. And in most circumstances, the insurance company are the part that usually behind the scenes retain the lawyers to negotiate or defend the matter.
And in your estimation, what are usually the award of damages for such type of claims?
Right. So there are different categories of losses. So to run through a couple would be general damages. That's what you call an unquantified claim. So someone has a concussion, based on their medical evidence, the court will look at precedents that was determined over the years and award some. There's also what we call special damages, which is your out-of-pocket expenses. So this would be a loss of earning domestic care, nursing assistance, transportation, if you paid for surgery and so on. There's also future claims. So you need a surgery in 10 years. So you can make a claim, look, I need a surgery in 10 years. I need the money now as part of my claim. Or I'm unable to work fully for the rest of my life. The court can give you an award.
And of course, all that is that taxed?
No, awards in the court is not taxable. However, in coming up with the award, dealing with the earnings aspect of the claim, loss of earnings, if the court can determine what is your take-home salary, if you're over the tax bracket, the court can apply taxable principles in coming up with the award. Hence, in the initial or the gross award, what you will see in the newspaper or the court order is not taxable.
And any closing comments, Prakash, with respect to employers' liability and their obligation to the employee?
Well, yes, and I think it's comments on both sides. The OSHA Act doesn't only set out the criteria what the employer has to follow, it also sets out duties of the employee. So employees really responsible for their own well-being as well. So if the employer is making certain suggestions for any workplace that the person is not comfortable with, the employee within their rights, I can't say no. And again, if they are not being victimized and so on as a result, this is an industrial court or a union matter could lead to that. So it's not strictly employers' liability. I know there are circumstances where employers are trying to force the employees to take the vaccine. Unfortunately, this is wrong. The vaccine is not mandatory, so employer cannot force at this time employees.
Well, we've seen that happening in Barbados, and that's a big debate.
Yes, so once the government doesn't impose that the vaccine is mandatory, at this stage, the employer cannot force an employee. And by forcing them, again, that's not necessarily employer's liability. That goes into victimization of the employee and so on, union and industrial court relations.
Right. So, guys, there you have it. in terms of employers' liability, all you need to know. Prakash, thank you so much for joining us and imparting that knowledge that a lot of persons indeed were looking forward to. So thank you so much.
Okay, thank you, Rondell.
Thank you. Pleasure. So guys, here you have it, employers' liability and what you need to know about employer-employee relations. You have been watching Strictly Legal on WESN Content Capital. Do have a great day. See you next time. Goodbye.